Half a day, everyone. Thank you for coming today. So this is the Committee on Health, Tourism, Historic Preservation, Land and Justice. It's a public hearing. This is October 3rd, 2019, and it's 5:09 p.m. Notices for this public hearing were disseminated via email to all senators and all main media broadcasting outlets on Thursday, September 12, and again on Monday, September 16, 2019. The notice was also published in the Guam Daily Post on September 12 and September 17, 2019. An invitation was sent to the Guam Medical Association on September 15, as well as the Guam Medical Society on September 16. And we had asked them to invite all their members. I would like to acknowledge the presence of my colleagues. We have Senator Kelly Marsh Taitano, and we have Senator Tello Taitagui. Thank you, colleagues. This is an informational hearing on the Guam Medical Malpractice Mandatory Arbitration Act and the impact on medical practice, standard of care, and the availability of health professionals on Guam. On September 19, we had the first hearing, and all testimonies from that hearing are on the website senatorterlahi.com. There's also a link to the hearing that you can watch, the audio and the video. The Attorney General and all members of the Guam Bar were invited to that hearing, and the public was also invited to submit testimony. For today's hearing, health professionals have been invited, and we've asked them to focus on the impacts of the current law on their practice, on whether the law ensures the appropriate standard of care on Guam, and the impacts of the law on the availability of qualified health professionals. I've invited the heads of the Guam Medical Association and the Guam Medical Society to lead the health professionals panel, and all their members to follow. And we will also hear testimony from additional attorneys who were not able to make the first hearing. And we have members of patients here also to testify, and members of the public. Seats for them, they're going to come up. That's the end of my list. Is there anyone else who was waiting to testify? If you could please check in with my staff. Please come up. Okay, Mr. Vera. I very much appreciate all of you being here and the testimony and the stories that are coming with it. It's really been an eye-opening night. Thank you. All right, so Mr. Lebowski, you can begin.
My name is David Lebowski. Thank you, Senators, for having me back again today. I am the father of Asher Dean Lebowski, who at age 5 passed away at the Guam Memorial Hospital on October 31st, almost 1 year ago. As stated in the last meeting, I would prefer to be anywhere else besides here, dealing with what I like to refer to as the blatant medical negligence and apathy that took Asher's life, with no accountability or even a public record of what the doctor did or didn't do. Then knowing the same doctor will be able to go off and see and endanger others on Guam, thanks to the Arbitration Act. Isn't it true, doctors, that under the Apathy Act, doctors could kill or injure many and we'll never know it, with all the protection it offers to doctors, with the built-in secrecy and privacy included, being covered by their colleagues? We heard Dr. Berg say, we're here because of one event, and public policy shouldn't be based on empathy or based on one event. But in fact, we don't know how many events there are. We don't know how many deaths. We don't know how many injuries, because the Arbitration Act prevents those from coming to light. It hides it. Then we hear the Arbitration Act being justified or rationalized as a standard of care issues to get doctors to Guam. This meeting is not about the doctors. This meeting is about real people. It's about the victims, about our kids, our family. And out of respect for some of the victims, it's about the death of Asher Dean. It's about the death of baby Faith. Joaquin. It's about the death of Aiden. It's about the death of Charlie. It's about Anelyn Lagrima's father, who we heard about his mistreatment last week at Guam Regional. And the list goes on and on of our injured and dead relatives and friends due to negligence and a legal cover-up with the Arbitration Apathy Act. Look around, please, doctors. Your victims have real faces. To be clear, what we are discussing here does not have to do with all Guam doctors. I want to make that perfectly clear. Guam has some great doctors. I've seen many, including being treated by the same dentist for 25 years. I have 6 kids who have been at one time or the other in the Guam medical system over the last 45 years. Yes, 45 years. Standard of care or standard of treatment for all of them was fine. That is, until Asher entered the Seventh-day Adventist clinic and saw Mr. Shishimiyagi on October 29th. Isn't this what we are talking about, really? Not the good doctor, not even the average doctor, but just that doctor who makes negligent mistakes and should be held accountable to protect all of us. All Guam doctors meet the so-called standard of care until they injure or kill somebody negligently. It's not about the ardent standard of care. It's about negligence by a few that the medical community as a whole want to protect in order to maintain their own personal interests. During the last meeting, we heard from Attorney Mitch Thompson and Attorney Bell, who practice on both sides of the aisle with claimants and defendants, both agreeing that the cost of arbitration is extremely high, tens of thousands of dollars, as we heard Attorney Keogh say today, making it near impossible to bring these cases to arbitration and to hold these negligent doctors responsible. Last meeting, I was astonished, really astonished, to hear Dr. Nguyen, acting president of the Guam Medical Association, state that we are confused about arbitration. That was his words. Confused? My gosh. He said this act isn't to protect the doctors. It's about the overall quality of care on Guam, and it helps to bring doctors to the island. I'm wondering if Dr. Nguyen has read the act. If the act is supposed to improve medical care or bring doctors to Guam and the concern is standard of care, why is the arbitration process as secretive as we heard last meeting? The doctors are already on Guam. It has nothing to do with bringing doctors here. Isn't that secrecy part of arbitration to protect the doctor? Not our families, not the community, to hide who did what? Please name any other investigative hearing or accusation of negligence on Guam that affords such privacy or secrecy. Why do we lose our freedom of speech forcibly when we agree to the forced arbitration? The proceedings prevent us from speaking about the issues. Then, why are we threatened? If we don't like the outcome of arbitration, that again is forced onto us, that we have to pay the doctor's legal fees if we want to go to court. Again, negating due process, a basic constitutional right. Shouldn't we know which doctors to avoid? Really, there's great doctors speaking today. There's great doctors on Guam. I've met many. But wouldn't that be prudent to know which doctors to avoid for improved medical care and choice? Isn't this outright? The whole standard of care that has been mentioned by Dr. Nguyen and others here today, and we've heard over and over again, is made up with no real proof. It's an excuse. Does Dr. Nguyen tell his patients that? Sorry that you are not happy at our clinic, but it's about the Guam standard of care. Or does he take responsibility? Or do other doctors take responsibility for patient issues or the many complaints? As I said earlier, I have 5 kids that had good standard of care in Guam and overall good or even great doctors. Asher didn't. Asher died. Maybe that's a national average. 17% get deadly lousy care. You can't sit here now and tell us that standard of care is not like California, Texas, as Dr. Nguyen did last meeting. It's laughable. It's laughable when you consider that medical errors, negligence in the USA, per recent studies, is the 3rd leading cause of death. Not one study, many studies. According to a recent study by Johns Hopkins, more than 250,000 people in the United States die every year because of medical mistakes, making it the 3rd leading cause of death after heart disease and cancer. Are you saying that our standard of care is worse than the States, as Dr. Nguyen implied last time and as we're hearing today, and that statistically more people on Guam die due to it or would die if we did not have the arbitration law? That's a good question. I'd like to have that answered. Extrapolating the statistical data for Guam based on the studies in the States, it would mean that we have around 107 or more deaths per year due to medical negligence. I bet no one in this room had heard that projection and never will either, as the Arbitration Act prevents these deaths from being reported accurately or covers up the medical negligence that we face and die from. These are studies that have been done over and over, and they can be checked by the intellectuals if they want. If we follow national averages on negligent deaths by doctors, why is it that we have one of the strictest malpractice arbitration policies in the country? It makes sense to me. Shouldn't we try to get rid of some of these bad doctors rather than exposing them to other children or family members? The argument that arbitration or Apathy Act would bring more doctors to Guam has not been proven here today or in the past. It's just talk. There's no statistics. There's no evidence of that. It's a meritless claim. Attorney Richard Pipes stated in a recent interview, it's a naked finding that there is no crisis in getting doctors, that no such crisis exists. So, who do we listen to? As 100 people per year die from negligence, projected statistically, do we listen to the doctors with the strictest malpractice policy of self-protection in the country, who have arbitration hearings privately that cannot be discussed? Or do we listen to attorneys like Attorney Keogh today or Attorney Pipes, who successfully argued the last malpractice law was unconstitutional? Or what about the national statistics? The state medical malpractice is an epidemic concerns, and we may be losing over 100 people or more per year on Guam to death due to negligence. Again, going back to what Mr. Berg said, we shouldn't base policy on one child. Since it's my child, I agree. We should base policy on statistics and real questions. How many people are injured or killed on Guam yearly? And why don't we know that? Oh, we don't know that because of the arbitration law. Do we listen to the families who have lost loved ones due to careless, lazy, apathetic, or mistakes? Do we look at the danger that is created by doctors who kill or injure, then practice the next day on the next unsuspecting patient due to the protection of arbitration? Under the umbrella of arbitration, how can you say that you are protecting the people of Guam and want to bring good doctors to Guam and improve standard of care? If this is true, why do you bring doctors to Guam who only meet minimal requirements and some have histories of malpractice already? Some of these doctors may not be able to work in other places. Not all, but some. How can you sit there and justify that? Then you bring these people here, give them protection under arbitration and privacy, and you put us at risk and act as if you're doing us a favor. This does not improve quality of care. This does not improve quality of care on Guam. Isn't it true among some of your community of doctors that some say Guam is known as a place to go to work as a doctor if you can't work in other places? I'm not saying that applies to the doctors here, and I'm not saying it applies to all doctors. But I am saying that there are doctors on Guam who have told me that, literally have told me that. It's a hidden secret. The Guam Medical License Board of Examiners licensed a doctor as an example in the States with more than one malpractice claim against him. God knows why they licensed him. And then they brought him out here where he negligently did the same thing to a Guam patient with serious consequences. We have no idea how many times this has happened, as it's hidden from us. Is this how we are protected by Mr. Nathaniel Berg and the licensing board? Is this how that board and the Medical Association Society are proposed to improve or maintain medical standards of care? By bringing these people here who hurt or kill us. According to a KUAM interview with Dr. Joan Gill, a Guam Medical Board member, she said, accessing information about your doctor in Guam is not as easy as it is in the States, where most medical licensing boards have websites with information available about doctors, so we can make informed choices. Dr. Gill said the board, the Medical Licensing Board, is hoping to implement the same thing on Guam. That was 8 years ago, but still nothing. Senator Tina Munya Barnes, about 8 years ago also, I believe, sponsored and passed the Patient Protection Through Information Act. This is all about a patient's profile being public information so that we can know who these doctors are, complaints against them. If you go to the pretty much non-functional website of the Guam Board of Medical Examiners, there used to be a dead link for this law. This is another example of how our medical examiners board doesn't protect us. They have not followed this law. This has been a law for 8 years. Have not set up the website and are trying seemingly to hide the bad doctors from us. Just like arbitration, it's all about protecting themselves at the peril of the community, even violating a law. Do we deserve the same standard of information as in the States? Isn't this information a factor of standard of care? Informed medical decisions? Why can't laws be broken to protect doctors, as the medical board seems to be doing? Dr. Gill also spoke about peer reviews when the board receives complaints about doctors. A peer review is a form of self-regulation by qualified members of a profession within the relevant field. It's not a radiologist reviewing a pediatrician's work, even though a licensing board may think that. Peer reviews, hardly ever happen, if ever. And my son Asher was never afforded what Dr. Gill said should happen, a peer review. Another step in the process that we as consumers should have, another step in the process that we don't, which protects doctors. Again, protection of doctors and apathy is the undercurrent of this, which pretty much again defines the Arbitration Act, along with some arrogance. It's obvious to us, not only as parents, but the community, that the local medical association and society and the Guam Licensing Board of Medical Examiners is about the protection of themselves at the peril of the community. The sad thing about it is there are great doctors on Guam, and I don't understand why they want to protect one or two here and there. The Arbitration Act, or the Apathy Act, is just another tool to silence us. I'm not going to focus on how the act discriminates against all of us, especially the poor. Guam doctors, as what most people think, most of them are great, but they're a protected class that looks down at the rest of us, which is evident in how many of them conduct themselves. Their testimony, not following the patient protection law, and their conflict of interest to cover for each other proves that, not to mention the Arbitration Act. Again, this does not necessarily apply to all doctors, but has become part of the overall physician culture on Guam, in my opinion. James Gillian gave testimony way back when the arbitration law was being enacted. He said doctors used to practice defensive medicine, but they were worried about being sued for malpractice, and that this Arbitration Act would alleviate that, as we've heard today, so they did not have to worry about being sued. Defensive medicine would be one less worry when the act passed. Well, I heard doctors here talking, we don't want to do defensive medicine, we don't want to do this, we don't want to do defensive medicine. Well, defensive medicine means to me that they were doing everything that they could for their patients, lab tests, and etc. Defensive medicine to me means being responsible doctors. Standard of care correlates with defensive medicine, not with arbitration. Baby Faith, 4 days without defensive medicine, had no lab tests that could have saved her life. Asher Dean, without defensive medicine, was left alone in a hospital room for 12 hours. Maybe if they were defensive, they would have been in watching him, not to mention what happened at the SDA clinic. How many have died over the years due to apathetic medical care on Guam as a product of arbitration protection, when apathy became part of our Guam physicians' culture? If the stats are correct, as mentioned earlier, at least 100 have died due to medical negligence since Asher left us. How many is that over the last 30 years since the act has been law? Let me repeat again. Asher Dean, Baby Faith, Joaquin Wacken, Aiden, Charlie, and many, many more. It's not standard of care or even arbitration that killed them. It's a few negligent doctors that did it that should be held accountable. With the Arbitration Act, there are no options for the average person with a valid complaint against a doctor, even though it was referred to earlier that there were. What do we do? Where do we go? Every system of medical care should have a check and balance system with protections for the citizens. That's also a variable of standard of care. I provided information last meeting, on how the Guam Board of Medical Examiners has failed us and is rife with conflict of interest. I didn't say it, but they have been referred to as corrupt in a local recent media report. They do not even allow for or follow the law dealing with the Patient Protection Through Information Act. Please, someone ask them why. Also, we have the Guam Board of Allied Health Examiners, who do not act on complaints, even the death of a child. My son Asher's 1-year anniversary of his death is this month, and they received a complaint, and they did nothing. It's been 10 months and counting, nothing done by that board. Nothing, zero. It's a useless board. I'm asking the doctors here right now, or those doctors on Guam, how many doctors on Guam have a history of claims against them for malpractice, and they were then licensed by the Guam Medical Examiners Licensing Board? How many doctors residing on Guam have complaints against them for malpractice or investigation of complaints for the public to be aware of? What's the secret? Dr. Gill said this is known in other places. Why do we not know it here? Isn't this our right? This right of ours is negated by the Arbitration Act. It's the law under the Patient Protection Through Information Act. I'll be honest with you. You know, you might be hearing a lot of anger in me, and maybe it's coming through in what I'm saying. But in my opinion, as I repeat myself, we have great doctors on Guam. But doctors should be ashamed of themselves with willful disregard and arrogance to lecture to us, telling us we are confused, which we heard last week, talking to us about standard of care, and trying to justify a law that kills us and protects them. Simple as that. We die, no one knows we died or how we died, and next day you're in your office. The self-serving attitude is now public record. The arbitration law is just one example, as I have stated, that show true intent of the medical community to protect their own, not including other laws. It's time to fix things rather than benefiting from this draconian arbitration Apathy Act. As Attorney Mitch Thompson accurately said during the last meetings, doctors do not want to judge their colleagues. There is no protection for us, the average person. The Guam Medical Examiners Board and the Allied Board have proven that over and over again. As some of the testimony we heard here today, trying to justify the act. My opinion is, any change in the arbitration law should not include Guam doctors to oversee complaints of other doctors. Per what Attorney Mitch Thompson said, what we have experienced personally and what we have seen and heard here today, they are not impartial and will not protect our interests over their own. I think the crux of medical problems in Guam are issues with care come from the Arbitration Act and attitude of those physicians that try to justify it. I said this before. It's too late for my son, Asher Dean. Nothing you can do will benefit him or us. Our suffering will not be alleviated by the repeal of this Apathy Arbitration Act. Nothing. Get nothing out of it. But I can tell you, we will take some solace to know that other families will not suffer as we and others have by making doctors responsible for destroying lives. If there is 107 deaths a year, we should know who they are. You know, Asher was taught the difference between right and wrong. He was taught the difference between right and wrong and to be responsible. Sadly and obviously, his doctors, maybe including some in attendance today, were not. Get rid of bad doctors. Do not bring more to Guam. Improve medical care on Guam. Save lives. Repeal the malpractice arbitration law. It will save lives and it will improve medical care on the island. It's a guarantee. Thank you, Senators.
Mr. Lebowski, thank you very much again for being here tonight and testifying and submitting your testimony in writing. It's been provided to all the senators and it will be uploaded also on the website. And I want to again extend my condolences to you. I know it must be very difficult. Ms. De Vera?
Good evening. My name is Monica Ann Nineti De Vera, mother of Charles Vincent Nineti Blas. Charles passed away at the Guam Regional Medical Center on January 23, 2016. As a mother, seeing your child pass away in front of your eyes is the most painful nightmare any parent should never have to go through, especially when you had placed your trust in the hands of the doctors. On the morning of Friday, January 8th, my son Charles had 3 seizures. The last seizure caused him to fracture 3 areas in his body. He fractured his right scapula, right femur, and his right hip. Not only did he suffer from epilepsy, but he was born with a medical condition called osteogenesis imperfecta, also known as brittle bones. That morning, he was transported to GRMC and was admitted. The operating room at that hospital was closed on weekends, so they scheduled him for surgery on Monday, January 11th. However, it was rescheduled to take place on the 13th at 9:00 a.m. The procedure was supposed to only last 45 minutes. Dr. Aropoulos, who was the physician that was to do the surgery, said it shouldn't take more than 45 minutes. Since Charles' scapula was only a hairline fracture and the femur had a rod inserted from the Shriners Hospital in Hawaii, he did not need surgery for those 2 fractures. His hips were the only area that the doctor said needed surgery to insert a screw fixation to the hip to help him move. The procedure was cut short and they did not push through with the planned surgery of putting the screws because they discovered that his bones were too brittle. As I waited in the waiting area, 45 minutes went by and there were no signs of the doctor. I get a phone call at 11:30 that morning, and he said that the surgery was canceled because he wasn't able to place the screw and the plate in because the bones were too brittle, that every time he tried to screw the screw in, the bones were too soft. Then he said he would keep him there for a few days, then discharge and recommend him physical therapy when he feels better. I then asked where was my son, and he said he should be out soon. I went to the front desk of the recovery room to inquire where my son was, and the nurse made a phone call to the back, but he was nowhere to be found. The nurse made several phone calls. By the 3rd call, she found him and told me to go up to his room and wait there because they were cleaning him up. That's when the nightmare began. At around 1:30 that afternoon, my son was wheeled up and looked like he was in so much pain. He said, "Mom, can you please ask the doctors for pain meds? Because my hips is really hurting." As I was reaching to touch his forehead, my son was so hot that I ran to the nurse to let her know that he was burning up and that he was asking for pain meds. Sure enough, his fever shot up to 105, and the nurses gave him pain meds and said that she will notify the doctors of his fever. With the room being so cold, my son was shivering, and I wanted to sponge bathe him to try to break his fever because I was afraid he might have another seizure. I even asked the nurse if they could turn off the aircon so I can sponge bathe him, and she said that the AC was only had one control and she cannot turn it off. I took a chance and sponge bathed him as fast as I could to try to break that fever. I had never felt so helpless until that day. From the day of the surgery to the 16th, my son was only given oxycodone and other pain medication to ease his discomfort. In the early morning of the 16th, Charles was given a chest x-ray and a blood culture test for bacteria. That same day, he started the vancomycin antibiotic. The nurse came in and was holding what I thought was an IV bag. I asked her what she was going to give him, and she said it was antibiotics ordered by the doctor. Every time they administered that antibiotic, my son would complain that the medication coming out from that IV line was burning his arms. Every time I brought it to the nurse's attention, they would always say that the antibiotics is very strong and that it's supposed to burn. If I knew at that time that my son was having an allergic reaction to that antibiotic, I would have made a stop. My son was not the average height and weight of men his age because of his osteogenesis imperfecta. His fever took several days to break after the surgery. Even after the fever broke, my son was not his usual self. The doctor decided to discharge him on the evening of Wednesday, January 19th. He was told to be discharged and follow up within a few days to schedule for physical therapy. That evening at around 7:30 p.m., the nurse came in and told me that he was getting discharged that evening. At around 10:30 p.m., a nurse prepared his discharge papers with instructions and a written prescription for pain meds, which I thought was awkward because it was really late in the evening and no pharmacy was open. No actual pain med was to be taken home. I went to the front desk and I asked the nurse, why can't they give him his medication to take home instead of a piece of paper? The pharmacies are all closed at this time. And they replied, not sure, Mom. It's the doctor's orders. I then asked why they can't just keep him one more night, since the 4th floor was not even full, so that my son can be given the pain meds at least till the morning. Again, the response, sorry, doctor's orders. It was close to midnight already. My son was being discharged with a broken hip, femur, scapula, and no pain meds to take home. Imagine that. On January 23rd, which was the Sunday morning that he passed, a Saturday morning that he had passed, I had to make a run to the bank and found my son listening to his music on his phone. I asked him if he wanted to eat before he took his meds, but insisted to wait for my daughter to wake up. So I told him I'll be back. Not even 30 minutes, I get a phone call. As I answered, all I kept hearing was my son in the background screaming, please tell Mom to help me. My heart is on fire. I told my daughter to hang up and call 911, and I rushed to the house. Shortly thereafter, the ambulance arrived. My son begged the paramedics from inside my home and en route to JRMC to help him understand why his chest was on fire and pleaded help him make the pain go away. As we arrived in the ER, he told the nurse, please help him make the pain go away, repeatedly. When the nurse asked him what his pain was from 1 to 10, he said it was 15. He continued to chant repeatedly, please help me, please help me. The nurse left and came back with something in a syringe, and my son asked if that was pain meds, and she said yes. Not even 30 minutes after giving him that shot, my son started vomiting. I don't know how many times I had to empty that vomit container, but he was vomiting blood mixed with a lot of white, thick fluids. He was panicking, and though his hip was fractured, he kept squirming in his bed, and ignored his hip pain, begging the nurses to help him for his chest. I ran outside to get a nurse to call the doctors, and the doctors came in. And they said that he wanted to get a CT scan done on him right away to see if there's anything in his chest that may cause any blood clots. As they were getting him ready for the CT scan, my son grabbed my hands and yelled, Mom, please don't let me die, Mom. I then told him, I promise I won't let you die, son. Those were the last words I had with my son, Charles Vince. Not even 5 minutes, I heard code blue CT scan room over the intercom. My mind went blank for a few seconds, and I grabbed my husband and begged him to tell me that it wasn't my son. We waited in the waiting room for over 2 hours before the doctors came out and said, I'm sorry, we tried to revive your son several times, but no luck. As we were going to see my son in the trauma room, I wished that it was all just a bad dream. But to this day, I still do. I felt helpless seeing and touching his cold body that afternoon, especially since it's been 3 long years and still can't get any honest answers. On the following Monday, January 25th, I get a phone call from GRMC saying that my son's remains will be forwarded to GMH to Dr. Espinola's office because an autopsy needed to be conducted. The autopsy protocol, since my son was a patient at GRMC, was discharged and came back and had passed away there. I inquired with them if I would be able to contact Dr. Espinola myself, and was advised that it was not required and to just wait for the autopsy to be completed. I received a phone call from Island Funeral Home on Thursday, January 28th at 4 o'clock that afternoon, informing me that my son's remains were at the funeral home. I was told that I was able to come down and prepare him for his viewing, which was set for Sunday the 31st. His funeral was set for Monday, the February 1st. As I was getting my son dressed up for his viewing, I inquired with Nancy Aquino, who is the owner of the funeral home, what was the final results of Charlie's autopsy. To my surprise, she told me that there was no autopsy done. I asked her why, and she said Dr. Spinola did not need to do one because he based his decision on what the medical records indicated was his cause of death. It was too late that afternoon to call his office, so the following morning, I called and found out that Dr. Espinola was off island and would not be available till Thursday, February 4th. So I made an appointment to meet with him that morning. During that meeting, I had informed Mr. Espinola that I had some concerns and told him what had happened to my son. He went on to mention that if he knew that I had concerns of my son's passing, he would have returned my son's remains back to GRMC to conduct the autopsy. But he said that he made his decision because GRMC only forwarded Charles's remains with the medical records of the day he had passed, and no other medical records was attached stating that he was hospitalized from January 6th to the 19th. He advised me that it was beyond his control now, and that the only resolve to issue is I take this to court. After I buried my son, I immediately went to GRMC to retrieve my son's medical records. After weeks of reviewing his files, trying to search for answers, I put several puzzles together to see what the actual cause of death was. My son was only admitted for fractures from the 8th to the 19th. Before his surgery, which was on the 13th, all his vital signs were normal and no fever whatsoever. All I could think of was that Dr. Aroflis went in, drilled his hip, hit his bone marrow, closed him back up, and caused him to have sepsis shock. Dr. Ali Insaf was the physician who prescribed the antibiotic, but I guess did not do his homework on the dosages because I sure did. This was what I discovered in the antibiotic pamphlet, that the vancomycin warning toxicity has occurred in patients receiving vancomycin. It has been transient and permanent. It has occurred mostly in patients who have been given excessive doses, which is hypertension. My son's heart rate and blood pressure was so high during the time he was given those antibiotics. The dosages were to be given by the weight of the patient. My son was only 84 pounds. The dosages were 250 milligrams on the 16th, they administered 4 times. Likewise, on the 17th, 4 times, and 1,000 milligrams 2 times on the 18th and the 19th. I know I'm not a physician, but those are the only explanation that I could think of that would have killed my son, overdose, which has caused his cardiac arrest. On June of 2016, I inquired with an attorney, Sergio Rufo, who was at one point practicing here in Guam, but he had moved to Hawaii. He stated that if I had that he stated that I had a very good case, but I needed to come up with $60,000 for the arbitration that needed to be filed within 1 year from his death. I was in shock because I had no idea that January 23rd would have been the last time that I would see my son, and did not prepare $60,000 thinking that he would pass away. To this day, I am still in debt with Our Lady of Peace because I had to prepare to bury my son. This meeting is to let all the families who are victims of this medical malpractice mandatory arbitration act speak up and let you see what this law is doing to all of us poor people. Protecting the doctors should not be a priority here. What right do these doctors have to just take our loved one's life and walk away like nothing out of the ordinary happened? This law needs some serious revisions because our loved ones are still not resting in peace. My son to this day visits me, and yes, you will think I'm crazy saying this, but believe me, my son's soul is not at peace because he was murdered while in the trusted hands of those physicians. I gave up at one point because I didn't have that kind of money. And 1 year, and the first year, and 1 year I was getting close. On December of 2016, I was reading the newspaper and saw another patient who was suing GRMC for wrongful death. I was overwhelmed and my depression started to worsen seeing that, so I went searching once again for another attorney. On June 22nd, 2017, I met with attorney Gloria Rudolph, and she took my case. We went to court in April of 2018 in front of Judge Sensen. The judge stated to have my case rescheduled because they wanted to wait for a decision of another similar case being heard by Judge Sicola. When the hearing was over, my attorney advised me to just hang tight and wait. Here I was thinking, oh, I shouldn't bother her because she said to hang tight and wait. However, in January of this year, I was browsing on my computer. For some odd reason, I'm not sure if it was my son giving me signs, but out of nowhere, I just typed my name, and what did I discover? A court document with my name on it. It was a court document filed by GRMC, which stated decision and order granting defendant's motion to dismiss. That was filed and recorded on May 4th, 2018 at 10:23 a.m. I immediately called my attorney's office to see if I was able to meet with her to try to get answers as to why I was never notified of this court hearing and why I was never given a copy. But she wasn't available, so I left messages for her to return my call. I made 10 calls here and there for about a month, but not once did I ever get a return call. Money is not going to bring my son, Charles, Asher Dean, baby Faith, Zachary, Joaquin, Aiden, and anyone else who I missed, who are all victims of this negligence. We just want justice and put a stop to these doctors in thinking that it is okay doing what they are doing. We all have repeatedly, time and time again, heard of this arbitration law, and we are all here today to plead for your help. So we ask this from you to please improve medical care on Guam, yes, work together in saving lives, and let's repeal this malpractice arbitration law. Having to relive this nightmare is very overwhelming for me and my family. Although it's been 3 years and 8 months that I haven't seen my son, I feel that I need to find closure for him. And by doing so, may his soul rest in peace, as well as all the other families who have lost a loved one. Thank you.
Thank you very much, Mr. Vera. And we're very sorry for your loss of Charles Vincent. Condolences, I know. Thank you for coming here today, though. Is Mr. Martinez still here? Or Dr. Berg? All right, or any other member of the Guam Medical Examiners Board? All right. So our final testimony today will be Anelyn Lagramas. Please proceed.
To be honest, I wasn't going to testify out of fear. Speaking like this really puts me and my dad at risk at the first hearing. I didn't expect this to be on the news, for some of the staff at GRMC to be upset with me, even to the point where one of the doctors had personally asked me to be replaced as my dad's attending physician during the following week. Not only that, but incidents of negligence that have never happened before just so happened to occur afterwards. So I also wanted to point out that his medication labels were switched for his wound, and was administered to him on multiple occasions, causing him to cry in agonizing pain. Had I not pointed it out and questioned it last week, they wouldn't have switched it, meaning none of the staff cared to even read the label. Also, the following day, his food orders were ordered pureed, and they mistakenly gave him a solid food tray. Had I not come on time, it would have put my dad in a deadly position. I also have pictures of these incidences. However, you should understand that now how unprotected my dad is with the current law. I have nowhere else to turn to but force myself back to publicly speak now and bring it out to light. They must be really sick of me and my dad by now, to the point that I fear that he might not be in safe hands because of me due to subtle retaliation. If it really isn't by coincidence, and if it helps, I'm sorry I was oblivious to think that you wouldn't find out. I did not intend for my dad's lack of care to be made known island-wide, and I thank you for all the hard work you've done thus far. It's not easy trying to reverse my dad's hospital-acquired bed sore. I just wanted you to know this is nothing against some of the hardworking staff at GRMC. Ironically, I have nothing against the physicians doing the best that they can and missing the signs of something as simple as a stage 1 bed sore. I'm actually against the fact that our hospitals are understaffed. Nurses understaffed, CNAs understaffed. In recent news, GRMC, under new management, had laid off about 40 staff. Not only that, but I also heard that among those 40 staff was the former wound care team that would have addressed my dad's wounds had they not been laid off. And now they're starting a new wound care team, ironically. I'm just trying to save my dad by all means. And if it means bringing this to light, then so be it. I just hope you do not take it against my dad, whose worsening condition already puts him in a completely helpless state. I come here to represent also the now 900 and counting Guam residents who have signed a petition to repeal the Triple MA. Is mandatory arbitration fair? All 50 of the US states don't impose forced arbitration on their people, yet only on Guam is our government forcing us to go through arbitration, where chances of a settlement are 0 to none. But we wouldn't know that, really, would we? Records of any malpractice and negligence cases are tossed out the window through forced closed-door arbitration hearings, so that no light is ever really shed on issues brought up. The basic question is, does it serve the people of Guam? The Triple MA, no matter how you defend it, really is biased. It's biased because you impose the burden of costs that could go up to hundreds of thousands of dollars on the poor to average citizen on Guam. Not only that, but that money can easily be tossed away through the chances of manipulated private proceedings. I believe in our healthcare system. I believe in our health professionals to trust in your ability and not cower to the court's due process just because of your title. The law carves out a special kind of privilege, somewhat close to immunity, but that isn't fair, is it? We should all be held liable for our actions and work ethic, so that in the end, people will know that you, in fact, did the best you can. But the triple MA makes us doubtful of that. It makes it impossible to really know whether you did your best without open due process. Otherwise, all the doctors testifying here are saying my dad's negligence case is baseless and without merit. Really? It's a hospital-acquired stage 4 bed sore, classified a never event. In the States, it's only allowable arbitration if the doctor gets his patients to sign off on arbitration agreements. And only some doctors actually have the guts to do that, many opting out reasoning that it makes them look bad to their patients. So what does that really say? Even the best doctors and hospitals in the US have to go through court to defend the work that they do? All I'm asking for is public and open liability because of the people of Guam deserve it. It's no question that people on Guam know someone that has complained about a hospital and medical care on island. Take example, GMH. How are they even able to operate in such conditions that are easily let go? So really ask yourselves, do you even have the people's trust? And should you impose forced arbitration proceedings on them? The triple MA was imposed 30 years ago. It's outdated. Recruiting doctors through means of protection is questionable. Because when you be after quantity over quality, quantity shouldn't even be an issue because insurances nowadays offer off-island treatment care. Defending the triple MA is like saying that these physicians and hospitals are 100% perfect. Everything they do is right and shouldn't be questioned in court. That they did their work 100% accurately with no flaws. I say that because arbitration is unrealistic and really biased based on a political system that if lawmakers don't support unfair means of something that is forced and imposed on the people of Guam, then they lose the support of the elite and the HMO and insurance companies. As for the standard of care on Guam, what really lowers the standard of care on Guam is when these issues are not brought to light, like my dad's bed sore. It makes me question, why is it only my dad that got a stage 4 life-threatening hospital-acquired bed sore? Who gets to determine the standard of care? What is it, not the standard of care that my dad's bed sore not preventable? I just wanted to inform you that damage done by the cause of his wound is extremely hard to reverse. And last I heard, the infection has reached the bone. And he is even more at risk of dying after being saved when he was first admitted due to a simple preventable never event that will probably never see its day in court. Knowing that there are national standards in place to prevent it, something as simple as turning the patient every 2 hours, and letting the family know the signs of a stage-1 bed sore. I had to find that out through research myself. Was my dad the only one that suffered from negligence like this? But we'll never know because cases like these are barred from entering the court. Is that justice? Is that what you call standard of care? Standard of care is not determined by hiding face, but openly and publicly accepting what went wrong in order to improve. Dr. Cabrera told me that when he spoke with me about my dad. Otherwise, how will we be able to learn from our mistakes? You see, the repeal of the triple MA as something to fear I see it as a light to bring awareness of the negligence that does happen. Why do you fear? If you in fact know and are confident that everything you do is right and ethical, why not trust the justice system just as you ask the public to trust negligence and malpractice to never happen in the medical system? Thank you.
Thank you very much, Ms. Lagrimas. I hope your dad is doing okay. But there are a couple things, I guess, that we don't have the answers to right now, and that is, I think, Mr. Lubofsky, you're right, that the GME does not have online yet some of the things that have been mandated by law, and we will follow up with that. And may I ask the panel, my colleagues, if they have questions? I know it's Speaker Barnes.
Julius Masi, Madam Chair, and I just want to thank everybody for being here tonight. And this is not very easy as we hear the stories from even family out there. But I know that in our efforts as policymakers to be I don't even know if fair is the right word to say, but I want to